I welcome three of my speakers, Mr. Sandeep Mahapatra, Asma Rashid, and Soumya Cham. I'd like to briefly say about Sandeep. Sandeep was the president of JNUSU during 2001. He was a charismatic student leader who, remember, he's from AVP and he won the JNUSU. It's not easy for AVP to win anything in JNU, even after that. So therefore, goes to remarkable charismatic leadership of Sandeep Mahapatra to win JNUSU hands down. That is itself is a remarkable achievement. It's a feat actually to celebrate it. And he's a practicing advocate in the Supreme Court. So he will represent legal fraternity on this issue. He will legal perspective on this, and he can add his own view. So that's briefly about Sandeep. And those of us would have seen him in NDTV, Times Now, and elsewhere. They will know that he represents BJP, and he's a spokesman for the party in various media forum. That's about Sandeep. And Dr. Asma Rashid, she is assistant professor in Department of English Language and Teaching, School of Distance Education, IFLU, English and Foreign Languages, University, Hyderabad. She has specialized in language policy. She worked on modern Muslim women's subjectivities, and she is a promising talent among young Muslim women's scholarship in India. And I would be happy if she could represent the Muslim women's perspective on Uniform Civil Code. Dr. Soumya Chama, she is associate professor from comparative literature in the University of Hyderabad. She is again a promising talent. She has published a book on cinemas and culture in South India, and worked on culture, nation, and minorities. She will primarily focus on the Dalit Bahujan perspective of Uniform Civil Code. She can add her own vision, and she can specifically address Dalit Bahujan perspective, and that will actually add new dimensions to the Uniform Civil Code debate. So with this, I now request Professor Vasanthi Srinivasan to chair this session and take it to its logical end.
All right. Good afternoon to all of you, and welcome to this webinar series of the School of Social Sciences. You would all agree with me that nothing evokes the partisanal passions more than the Uniform Civil Code, and perhaps nothing soothes and tames those passions more than a spirited conversation among friends. You would also agree with me that nothing is more conducive to exchanging some intellectual punches from a safe distance as the virtual medium. So I hope that the three speakers today that we have, who all come from different political perspectives, will enlighten us on the necessity, the possibility, and the desirability of a uniform civil code. Without further ado, let me invite now Mr. Sandeep Mahapatra. I think the way this works is 20 minutes per speaker, and then followed by, eventually after 1 hour of presentations, followed by 20 minutes of Q&A. All right, welcome Mr. Sandeep Mahapatra. You can take over now.
Thank you, ma'am. Thanks a lot. Professor Dr. Patnaik, the Dean of Student of the School of Social Sciences, Hyderabad Central University, Dr. Vasanthi Srinivasan, my co-panelist, Ms. Asma Rashid, and Ms. Soumya. First of all, thanks to Dr. Patnaik for having initiated this dialogue. And as he said, that this is the first in the series. And I'm hopeful that going forward, there will be many such debates and discussions on various relevant issues. And as I could see from the people that have logged in, I could see people from Jharkhand, I could see people from Kerala, and it will not be wrong to say on my part, to say that people from all over India have joined in, and that shows that the kind of interest that has been generated by this topic. So, as Ms. Vasanthi Srinivasan has already pointed out, this is to be a debate will be debating and we'll be sharing our thoughts as to the probability, possibilities, and of course the impediments about bringing about an UCC. And therefore, to understand the concept of Uniform Civil Code and how it is required, and I'll be speaking in favor of the motion that there has to be a Uniform Civil Code. And for that, please allow me to elaborate on the historical significance and the historicity of the Uniform Civil Code. Many of us would like to believe that it all started with the debate in the Constituent Assembly. And thereafter, many debates that took place in the last about 70 years of we being declared as a republic in 1950. But I would like to submit before you that long before the Constitution was adopted, long before the Constituent Assembly came into being, the issue of Uniform Civil Code was debated in the colonial era also, and particularly in the 18th century, when the Britishers and East India Company was setting its foot all over India. They tried to bring about an uniformity, or they thought about whether or not an uniformity could be brought about. And initially, in the first few decades of the 18th century, the idea was that insofar as the personal law aspect of Hindus and Muslims are concerned, let's consult the Pandits and the Qazis so as to get an understanding as to what is the personal law of the Hindus and Muslims are all about. But it so happened that there were so many views coming out from the Pandits, so many views coming out from the Qazis, that the administrator or the judges, if I may use the term, got so baffled that they took up the task of reading the text, the various Hindu text and various Muslim text or Islamic text, to get a feeling as to what personal law is all about. And that's how what developed was an Anglo-Saxon kind of basis the English law, they tried to interpret it. And this continued for about, if I'm not wrong, about a century. And in 1835, when the British government formed a law commission, that was the second law commission that was formed, and it was tasked also to study as to whether the atmosphere was conducive in India at that point in time to have an uniform civil code. I would request the participants to mute themselves because I could hear some kind of disturbance. I would like the chair also to sanitize kind of the participants. Thank you. Thanks for the intervention. So as I was saying, this was in 1830s, early 1830s, 1835 to be precise, when the second law commission was tasked with this issue of whether or not bringing about a uniform civil code was the right thing to do at that point in time. And those who were part of the law commission at that point in time, they were of the view that given this situation in India, the time was not ripe. And please remember these words, time is not ripe, because this gets repeated over and again in the next 100 years and even now also. And therefore they said that let it be, let the Hindus be governed by their own personal law and Muslims be governed by their own personal, customary law or whatever. But what is, interesting to note is that post 1835, there are many laws that were brought about to codify or to give a to codify the law that governs personal law space, that governs Hindus, Christians, and Parsis. And as we would see later on, that between this period of 1835 till we got independence, many laws were brought about, many codifications happened, many legislations were passed. And these are all in respect of the Hindus, the Christians, and the Parsis. Insofar the Muslims are concerned, it happened that in 1939, 1937, the Shariat law and other laws were, codified to some extent, or they was brought about to some extent. But the point remains that in that historical background, when the Britishers were struggling to, consolidate their position in India, they thought it prudent on their part not to interfere with the systems or customary systems that was prevalent. But having done that, they also went ahead to bring about changes insofar as the rights of Hindu women are concerned, be it inheritance right, be it the right of a widow after the husband dies, what would be the property right of such a widow. In case of Parsi, they passed a Parsi Succession Act. In case of Christians also, they passed legislation regarding inheritance and matrimonial matters, marriage and other things. And in the intervening period in 1857, as we all know, that was the first rebellion of independence. the Britishers were rattled. The East Indian Company, the powers of the East Indian Company was taken over by the Crown. And since 1857 happened, the Britishers became very circumspect as to whether or not to go about codifying the customary law. But as I said, having in this premise also, they still went ahead and legislated various aspects insofar as the rights of Hindu women are concerned. And this continued till the 20th century also. And in the first 2-3 decades of the 20th century, they passed various legislations which related to the inheritance rights of Hindu widows, and some aspect of the Christian law succession and other things are also codified. But insofar as the Muslim personal law is concerned, it was not touched. One of the argument that is given, or one of the explanation that is given, is maybe that it was part of the divide and rule policy that was followed by the Britishers, and that continued till independence. So this was the background, historical background, that we need to understand, I would submit, about before talking about uniform civil code. That number one, there has been efforts that have been made in this country for the last about 2 centuries or more to provide or talk about or discuss about uniform civil code. Nevertheless, even after 2 centuries, we are in a position that we don't have a uniform civil code, and therefore the topic that we have chosen assumes importance. So now coming back to the last, the last point that I was making about the 20th century, the developments that took place in the 20th century. In the early 1940s, there was a demand by a commission, and that was, that included women also, which spoke about uniform civil code. And it was in 1940, they propounded that uniform civil code has to be in India, because we are going to get independence. If not today, tomorrow we are going to get independence. We'll be a modern state, and therefore it is necessary that we need to have a uniform civil code in place. And they may have got boost from what was provided in the 1935 Act that was brought about by the Britishers, because it also emphasized in some manner about uniform civil code. And in this background, in 1941-42, a committee was set up, headed by B.N. Rao. And as we all would know, students of law, students of political science, B.N. Rao played a crucial role insofar as drafting of constitution is concerned and drafting of various legislations are concerned. The B.N. Rao committee that was formed in 1942 was to specifically look into the aspect of codifying Hindu personal law. It submitted its report in due time, but it so happened that the report could not be acted upon, and in the meantime, we got independence in 1947, and the Constituent Assembly was formed so as to debate and discuss as to what form of a constitution we are going to adopt. And the Constituent Assembly also debated about the Uniform Civil Code. And as we all would be knowing, that the debate in the Constituent Assembly regarding Uniform Civil Code was as heated or as passionate as it is today also, even after 70-75 years. And therefore, there are members who are supporting the Uniform Civil Code to be made part of the fundamental rights. There are Muslim members who opposed it to be made part of the part of the fundamental right. People like Baba Sahib Ambedkar was of the view that as a modern state, as a state which is adopting a constitution for itself, as a state which is a republic in itself, we should be forward-looking. And he gave a very good illustration so as to assuage the feeling of the Muslim members who were at that point also saying that it is playing with their personal, customary law. He said that, look, till the other day, till about 1939, insofar as the northwest frontier province in Pakistan, which was Pakistan, though part of India at that point in time, in 1939, later became part of Pakistan, the Muslims were governed by the Hindu customary law. And therefore, even today also, certain part of those people, or the northwest frontier province, they are still governed by the Hindu customary law insofar as their inheritance right or marriage and other rights are concerned. He also gave examples about various other Muslim groups in India who were resident of, say, Kerala, maybe in Malabar and certain other places, whose customary law has got inspiration, so to say, or was governed by Hindu customary law. And therefore, he said that, look, it is not that we are going to replace everything that you believe by a different set of codified law. It is just that we want to bring in place a uniformity insofar as the civil law is concerned. And to the argument that why an uniformity, what Baba Sahib Ambedkar said at that point in time still resonates. And he said that, look, Today, when we have got independence, we have got our Constituent Assembly, we also need to look into the various legislation that we have today. Insofar as the criminal law is concerned, it is one for everyone, irrespective of the denomination. Insofar as the evidence law is concerned, insofar as the Transfer of Property Act is concerned, insofar as the other contractual civil law is concerned, it is one and the same for everyone. So why not a uniform civil code for everyone to go forward? But as we all know, it did not materialize. And as a compromise, I would say, Uniform Civil Code got a place under the directive principle of state policy at Article 44. And later on, the 1942 Rao Committee report that was given for Hindu codification of Hindu customary law, Hindu laws, that got kind of life later on in the mid part of 1950s. And for 1 year, 1955 to 1956, 4 different legislations regarding the marriage, guardianship, inheritance right and succession, etc., for Hindus were brought about, and that generated heated debate at that point in time. And as student of political science and law, you would recollect that Dr. Rajendra Prasad was not in favor of this. Baba Sahib Ambedkar also had to resign because he thought that Uniform Civil Code should have been brought rather than in this manner, rather in a piecemeal manner. It has to be a all-out affair. So that was the historicity insofar as post-independence from 1948, about 1947 to 1955 is concerned. From 1955 to 1985, we see a period where many changes were brought about. The Dowry Prohibition Act was brought about so as to prevent harassment regarding dowry, but it excluded the mahr or the dowry that is given in a marriage solemnized under the Muslim law. And there were other legislation that were also brought about, which kept the Muslim populace out of that ambit. But in 1985, everything turned around. When a Muslim woman is at about 70 years of age, her case reached the Supreme Court, and we know about that case, Savano's case. And the Supreme Court was aghast to see that even after adopting the Constitution, 35 years of adopting the Constitution, we are living in a situation where there is no uniformity insofar as the civil laws are concerned. And no less than a person of the stature of Justice Chandrachud, who is the longest serving Chief Justice of India, and he is remembered for his various judgments. He was of the opinion that the time has come that the government should act on this, and a uniform civil code should be brought about so as to bring about uniformity in aspect of personal law is concerned. That led to a very peculiar situation. In the beginning, everybody was in favor of that, and including the people from the left, the activists from the left, who were gung-ho about this. They were of the view that yes, uniform civil code has to be brought about. And I am compelled to refer to a speech that was made by EMS Namudripad in 1985. And he said that, look, we in India is a democratically governed country. We have a constitution which talks about equality, which talks about fraternity, which talks about secularism. And therefore to say that, even if we are a citizen of India, we still follow our age-old system of marriage, will be polygamous, it will not do. At that point in time, this was around 1985 or 86, if I remember correctly, Indian Muslim League, faction of the Indian Muslim League, was in partnership with the CPM in Kerala. And they got very agitated. They took out a rally, I think in Thiruvananthapuram, and they issued threats, if I may use the word, to say that, look, Mr. Namudripad, remain within your domain. If it comes to that, we'll marry your wife, we'll marry your daughters, and so on and so forth. So from that day onwards, till the day Mr. Namudripad passed away in 1998, he never spoke about Uniform Civil Code, and that was the end of the road insofar as the Uniform Civil Code and the left parties are concerned. At that point in time, Mr. Rajiv Gandhi was heading a stupendous majority government in the Indian Parliament history. Had it been the case, he could have passed, or he could have started at least a discussion about Uniform Civil Code, but he also capitulated. And as we all know, the Savano judgment was overturned by passing a legislation which purportedly dealt with the rights of Muslim women, the divorce or post-divorce. But nevertheless, the momentum that was generated by the Supreme Court judgment was lost on us. And till now also, the momentum is being tried to be built up, but then nothing is happening on the ground. But nevertheless, post 1985 also, the Supreme Court had the occasion to visit the issue of Uniform Civil Code on many occasions. Be it the case of Sarla Mudgal, be it case of, in 2003 headed by Justice V.N. Khare, and as recently as 2017, the Triple Talaq case by Saira Bano, and in 2019 also, which dealt with the issue of Uniform Civil Code in the context of Goa. The commonality and the common thread that is there between all these judgments, that the Supreme Court has always exhorted the government to bring about an uniform civil code. And in 2018 or 2017, when this Triple Talaq case came, the same argument that was being raised rather in 1985, that you are playing with our identity, the time is not ripe. Again and again, you are trying to subjugate us, the Muslim community, to the majoritarian Hindu community. Those arguments were, built up. And the time is not ripe argument goes back to Pandit Nehru in 1955, when he was faced with this question, or when he was asked about why no uniform civil code is being brought. Then he had said at that point in time that the time is not ripe. But the fact remains that the argument that was made by Pandit Nehru in 1955 is still being used and still in vogue for various obvious reasons. So, Triple Talaq from Saravano to Saravano, the Supreme Court has always taken a view that in a constitutionally mandated state, constitutionally governed state, the government of the state should endeavor to bring about uniformity insofar as the civil code is concerned. And it is not dictated by any political ideology, but it is dictated by the very principles of the constitution that is embedded in the preamble itself. It talks about equality, it talks about fraternity, it talks about secularism. And therefore, even today also, when we are debating the issue of constitutionality or the issue of uniform civil code, the same arguments are being given. That number one, insofar as the Muslims of India are concerned, they are only being targeted. So there are some fallacies that has been built up over the years, and I'll rather try to deal with all these fallacies, and I'll make my submissions on all these fallacies. The first fallacy that is, or the first argument that the other side would say is that why you are only being specifically targeting the Muslim community. And the simple answer to that would be, in my humble view, is that insofar as the other communities of India are concerned, everybody, be it Hindus, be it Sikhs, be it Jainas, be it the Parsis, be it the Christians, they are being governed by certain codified system of law. And therefore, you being the citizens of India, it is your bounden duty to at least talk about this rather than denying it wholesale, saying that it is not happening, number one. Number two, the second argument that is being built up, or the second fallacy that is being given, is that at the end of the day, Article 44 is part of the directive principle of state policy. It is non-justiciable, and therefore don't talk about directive principle of state, something which is mentioned in the directive principle of state policy. It cannot be made a part of legal formulas. The argument that is built basis the directive principle is belied from the fact that over the period of time, from 1950 when the Constitution was adopted till now, the Supreme Court and various legal authors, various legal scholars have opined that directive principle of state policy and fundamental right, chapter 3 and chapter 4, are complementary to each other. And while talking about, or while examining or scrutinizing various legislations on the touchstone of the provisions of the fundamental right, it is the duty, or rather the courts have taken the approach of weighing those legislations on the touchstone of the directive principle of state policy. Thirdly, we also need to know that various aspects of directives, the principle of state policy, have been given a concrete format. Just to give you a few examples, right to education has become a fundamental right. It was part of DPSP at certain point in time. Now it has become part of the fundamental right. Legal aid, it is there in the directive principle of state policy, but now legal aid is universally acceptable in India, and a destitute has the right of legal aid, and therefore that has been taken again from directive principle of state policy. Thirdly, equal pay for equal work, irrespective of gender. It is also part of the directive principle of state policy, and now it has been legislated and it has been recognized. Fourthly, there are other aspects of directive principle of state policy, like shelter to the needy, like other issues that are there in the directive principle of state policy, where the state is exhorted to be guided by the directive principle of state policy. Those have now been given concrete shape, including Panchayati Raj system. So therefore, that argument about it is being part of directive principle of state policy, according to my humble view, does not hold water. The fourth or fifth argument that is given is that Muslim women don't complain. Why are you imposing something which is not being demanded by the Muslim woman? But by saying that, we are trying to negate a large section of Muslim women who have become very vocal, as we have seen over the period of time. Apart from Muslim women, there are organizations like Muslim Satya Sodak Mandal, which has been working in the sphere, to modernize, so to say, or codify or for the rights of Muslim women. There are many Muslim organizations which are working all over India on voicing concern about the rights of Muslim women. There are people like Jakia Soman, and there are others who have taken off the cause of bringing out a model Nikanama or modern Nikanama, so that the rights of the Muslim woman who is getting married is enshrined. And the sixth argument is that look, we are a separate, we have separate denomination, and therefore we should be allowed to follow this. The problem with this argument is that this argument was given during the triple talaq debate also, and in some manner it was sought to be raised before the Supreme Court also. But faced with the counter argument that even the Muslim countries, be it Pakistan, be it Indonesia, and be it various other Muslim-dominated countries or Muslim-governed countries where it is a theocracy and it is an Islamic state, triple talaq. Okay, I'll conclude. Triple talaq is not allowed. Likewise, insofar as the Uniform Civil Code is concerned, various countries like Turkey, Tunisia, they have modernized their system. They have brought about a modern, legal system, so to say, to govern their populace. And insofar as the polygamous argument that is being, talked about, one argument that is given is that polygamy is more prevalent amongst the Hindus. They convert into Islam and then they marry for the second time. But if that be the case, don't you think that the Uniform Civil Code will bring a stop to that, if at all this is happening? And secondly, if at all you are saying that this is as per the Islamic practices, please do remember that even in countries like Pakistan, which was born out of India, insofar as the second marriage is concerned, it has to be, the permission has to be taken from by following a process. Even Bangladesh follows that. Even other Muslim countries like Iran and other, they follow that insofar as the polygamy aspect is concerned. And the most vital aspect is that when we talk about basic human rights, and that is enshrined in our constitution, is it not the time to ask ourselves this question, that whether the Muslim woman, for that matter, or for that matter, any section of the women who are being deprived of their basic rights, is it not their right to talk about uniformity insofar as this aspect is concerned? And the last argument that is being built up is based on, what about undivided Hindu family? Undivided Hindu family is a concept basis income tax law. If need be, that can be relooked. But the bottom line that we need to remember is a discussion has to be started, going beyond the binaries of Hindus and Muslims. This discussion has to go on. Otherwise, we'll be again going back to the same old argument that the time is not ripe. Don't fiddle with anything. And again, this binary will again build up. And of course, if you are saying that, if you are saying that you are part of India, you are citizens of India, you need to understand that we are governed by the Constitution. And we have seen this in the recent past also, that the Constitution or the preamble became the symbol of protest that we saw in various parts of India. And if you believe in this, then you also need to believe, and we also need to adhere to this, that Uniform Civil Code. Maybe there are very many impediments. There might be, I am not saying, but then the fact remains that a beginning has to be made. It cannot be just whisked away saying that please don't fiddle with our personal laws, because fact remains that except for Muslim community, the law in some manner has been codified in democratic India and constitutionally governed India for other communities. And therefore, my submission would be that the time has come that let's talk about Uniform Civil Code in an open mind. It is for the betterment of the country, betterment of the 135 crores of Indian populace. And in the long run, when we are talking about making India a superpower, this is going to add to achieve that dream. With these words, I again thank you for giving a patient hearing to me. I'd be happy to take your questions. I've broadly touched upon the issues regarding UCC and my views without going into the politics of it, because I thought that it is better to talk about the legalistic aspect and the possibilities, as Dr. Basanti had suggested. And therefore, whatever questions will become, I'll be taking those questions in my question answers. Thanks a lot. Thanks a lot again.
Thank you, Dr. Mahapatra, for laying out the constitutional and legal perspective, but also touching upon some of the political aspects which are inevitable on a topic like this. Following the principle that we invite our guests from outside the university first, I now request Dr. Asma Rashid to make her presentation. The same thing, 20 minutes, and when you are close to 18 minutes, I'll raise an alert. Thank you.
Right, so I began by thanking the Dean and the School of Social Sciences for having me for this introductory event in their webinar series. It is an exciting way to involve people and continue to remain engaged in conversations, even though we are unable to meet face to face or in close contact with each other. I'm very happy that my previous speaker has touched upon several points which actually bring into the space what I would like to also touch upon. I am not a legal expert, I'm more a scholar, and I would like to pick up some of the points around this issue from a trajectory of how feminism has worked with this issue, how women and women's groups have looked at this, different kinds of events or different kinds of cases or points in which they have tried to bring in questions of rights, questions of equality, and so on. Now, when we look at the Uniform Civil Code, it's more a story of how communities in the Indian context have come to be, as far as I can see and as far as many other scholars have pointed out, it's about how communities in the Indian context came to be uniquely identified in the struggle of women. That women became this ground on which, from the colonial period to the present, things have to be laid out. Also, the story of women and culture today, not just today, but yes, culture also, I would say, is practically coterminous with the trajectories of religiously defined communities and their respective patriarchies. Now, my friend, Professor Soumya Bechamma is going to speak, from what I hear, about caste, and so I am not going to go into that because that is another area where we'll think about, when we think about UCC, a different perspective and different kinds of questions come up. So I'll leave that for to be picked up later. But I think 1929, I mean, Sandeep Patra probably knows better as a lawyer, but Sardar Act, which is something which picked up the 19th century debate over raising the age of marriage. And this issue is once again in the news because recently it was announced, it was reported that we are going to have a task force, a committee is being set up to look into raising the age of marriage further. But according to most histories of women's struggles in India, Sardar Act is one of the initial moments when women actually were both the subjects and the objects of change, that they were, even though there were a lot of other imperial and nationalist alignments that played a part, it was in 1929 where they got involved in it. In 1934, there was this All India Women's Conference, which also petitioned the government to set up a committee to investigate the legal disabilities of women, so to say. And the secretary of that organization at that point said that something to the effect that we must have new laws for all women, irrespective of community. So the idea was that such laws would alleviate women's suffering, a point which my previous co-panelist just now made, and also provide them with greater independence. Interestingly, the argument was framed that this is not in terms of a Western paradigm of a sex war or Western society, but it in terms of allowing India to join a modern and progressive state. There was also this report which was made public in 1940, and this was a report on the role of women, women's role in a planned economy, that the country was going to come into its own. British India would now become India, and this was a product of some 29 or so subcommittees which were set up by the then political parties, and in order to prepare for when a national scale planning, etc., will come into operation. And Mridula Sarabhai, I think, was the secretary of a very large subcommittee for this. Now, that report had a chapter on property rights, and they recommended a common civil code. There's a lot of debate on what is a common civil code and what is a uniform civil code and their differences. Perhaps that will come up later. But so private property is a matter of concern. It's a question of inequality. That was it was the root cause of many inequalities, it was argued. But as long as there is private property, there has to equality between men and women will require that there should be right to property. That's how it was. This report, which was made public in 1940, also talked about how diversity of personal laws cannot have a future across religious communities, across regions, etc. And they said that no national plan can entertain such communal diversities which result in inequalities between men and women, governed by the same state. So you can see there's a small shift in language which is happening. Interestingly, this report took up a lot of space about Hindu law and its shortcomings, and made references to the more liberal treatment when it came to property rights and so on under the Muslim law. Although, of course, it acknowledged that it was not sufficiently practiced on the ground. So law as it is in the books and law as it works out on the ground, we all know that there can be differences. Anyway, there are more such things, more such debates which happened when the Constituent Assembly is set up, when there are the Constitution is being framed, and so on. And as we already been mentioned, that the UCC finally found its way into the directive principles. Now, of course, the directive principles, there are many good things that have been right to education, etc., which have actually been transformed into legislation. But I would take a minute here to just point out that the directive principles also talk of a living wage for all people, and we know that in the contemporary economic distress that everybody is facing, we don't even have a basic minimum wage for all our people. Anyway, to come back to the story of the narrative that I am trying to cull out in terms of women's rights and differences there. The 1970s has a lot of laws which come up, the dowry harassment, yes, the laws on violence, on there are lots of interventions which are in the sphere of criminal rather than personal law. That's the difference that I'm trying to put here. The 1975, which was the UN Year of the Woman, that had a Towards Equality report. This also had a chapter which looked at the status of women, chapter 4, if I'm right, and it looked in terms of women's status in terms of themes, the themes of marriage, of divorce, succession, maintenance, so on. And the position of different personal laws within each theme was evaluated. So this is how it was set up. What it did do, perhaps unintentionally, it highlighted how it was relatively recent that there had been reforms in the Hindu personal law, whereas discussions on Muslim personal law were much earlier or older, pre-independence in fact. But in each theme, basically, the lack of uniformity was emphasized. And in another chapter, and since we just had this mention of polygamy, the status of women commission noted that from using statistical data from 1961, they noted that the percentage of bigamous marriages was slightly higher among the Hindus than the Muslims. Anyway, that is all a different basket. I am not interested in going into those kinds of tangents, but they also saw the legal sanction of polygamy among the Muslims as a problem. That is a different issue. It violated fundamental rights of equality, etc., etc. Let me now shift a little bit in time in terms of to the 1980s, the Shah Bano case in 1985, which marked a watershed moment as far as feminist thought in India is concerned. This is, of course, as was mentioned, an elderly woman. She was divorced by her lawyer husband, and she approached the court for maintenance, and she used Section 125, which had to do with compensation for destitution to prevent vagrancy. And the court at that time awarded her this humongous amount of 179 rupees. And then it made remarks about Islam and the need for a uniform civil code, and which is when this whole issue once again exploded. It assumed it got other kinds of dimensions, took on with it. So the public pressure, unfortunately, from all sides was such that the woman herself withdrew the case, and she just disappeared from the public scene. And in 1986, the then government enacted the Muslim Women's Protection of Rights on Divorce Act, which codified some segment of Muslim personal law so that a lump sum amount could be given as maintenance, etc. In fact, Flavia Agnes in 2013, she's noted in an article that this was an immensely historically significant moment because this was the first attempt to codify this segment, and that it allowed women to get this lump sum amount, whereas payment of maintenance every month can always be a dicey feature. So, but the point is that when the 1985 post-Shah Banu case comes up, this is a point which becomes a very, very difficult moment for feminist thought in India, because this is a point where we have to confront this idea that there is something else happening in terms of taking the issue or the debate elsewhere. There was the usual standoff between religious tradition on the one hand and women's rights on the other hand. And all this was happening on the quote-unquote secular terrain of criminal law. And in effect, of course, in this whole debate, the woman herself got sucked in, and she got swallowed up, if you like. Another similar thing which happened, was not similar, but an issue which sort of gained traction in 1987, shortly thereafter, when all of this is being debated, is the immolation of a young woman called Roop Kanwar. This was in Rajasthan. And she, once again, when she was trying to immolate herself, this whole talk of tradition and one's community and one's religious traditions, all of these was once again raised in order to defend, or in order to justify, in order to say that she had the right to say this. Now, basically then, when it comes to the 1990s, we are looking at discussions or debates on whether we need a uniform civil code, whether there are new ways of looking at it, whether there's a different foundation that we can give to this whole debate. In fact, if you're talking about the left, this was a time when somebody from the left, I forget who, but one of the public figures spoke up and said that there is uniformity in matters of contract, in matters of civil and criminal procedures. That has still not brought about national integration. So why do we require umbrella legislation in the sphere of personal law? So not uniformity, but equality. That was one of the important points that was coming up in. That should be the focus. Equality both within and between communities, which will allow plural or different traditions to flourish. This was 1990s, is also the time when community becomes a major point of discussion as far as scholarly debates are concerned. That there was this whole one strand or stream which was opposed to any state-led reform and said that India is a place where we have living traditions and our communities have the right and the power to change, to use their customary laws, etc. There were also people like Kungum Sangari who said that there are multiple and overlapping patriarchies, and therefore we require state intervention. Now, as far as the Uniform Civil Code is concerned and the present is concerned, yes, post 1996, on the other side of it is also something which happens is there are a lot of debates and discussions about reforms from within the community. On the one hand, there are discussions of what is community, etc. And there are also discussions about whether we can have reforms from within the community. And in fact, the previous speaker has mentioned the model Nikahnaama. The Nikahnaama comes into discussion. For example, there was a model Nikahnaama in the 1930s, which the president of the AIWC, All India Women's Congress at that point, Sharifa Hamid Ali, had prepared a draft of Muslim marriage contract, the Nikahnaama, which was to allow or enable or empower women to initiate divorce under certain conditions. So the idea of a model Nikahnaama has certainly been there for a very long time. In the 1970s, Sir Syed Ahmed's great-granddaughter or somebody had a very elaborate Nikahnaama during her wedding, which prohibited polygamy, which set up conditions under which, if there was a divorce, custody of children would be sorted out, how there might be reconciliation, who would oversee reconciliation, etc. So basically, the issue of a model Nikahnaama in making this case has been around for a very long time. It's been discussed and debated, and there are differing opinions about it. But the argument that I would prefer to push is that what we need are greater, or larger, or more closer reforms within each domain rather than going in for overhauling or sweeping things. For example, there have been repeated demands about compulsory registration of marriages. 1 minute more, are you saying that? Okay, your mic is muted, I can't hear you. Right, so in 1 minute more, I'm supposed to wind up. All right, so there have been demands for compulsory registrations of marriages. There have been a need to address problems in the Special Marriages Act. There is a Juvenile Justice Act, which now allows for adoption and other kinds of things that were not there earlier. So the idea of setting up a rights framework for people, right, persons, individual citizens, if you like, in intimate relationship, the idea of rights, not just human rights, but rights for citizens in intimate relationships that fall outside existing marriage laws is also something that has been talked about. And finally, when we talk about empowering Muslim women, that's a very good idea. I'm happy about it. But I would think that from what all different kinds of articles and now visibility, larger visibility in the last 10 years or so of young Muslim women from within the community, that now there is a shift, or there is more of a focus on empowering us through education, through healthcare, through employment, through other means of sustenance, etc., and reducing one's identity in terms of one's community. It seems to be a rather reductive move rather than an empowering move. The question here then I would say is that how much space do we have in terms of civil rights to redress the issues experienced by an individual who is subject to more than one paradigm of social power, not just religious identity, but other paradigms of social power which define us as well. All right, shall I stop here? I'll take up any other questions later. Thank you.
Thank you, Dr. Rashid, for a very balanced presentation. Let me now invite Dr. Soumya Dechamma from the University of Hyderabad to make her presentation.
Thank you, Asanti. Thank you, Professor Patnaik, who invited all of us. Thanks to Asma and Mr. Mahapatra as well. Yeah, like Asma pointed out, to be in midst of political scientists and a legal expert in a debate on UCC is not an easy thing. Let me try, and this won't be a historical narration or a law-based kind of a presentation, but I'm picking up various threads, various narratives, and trying to put an argument, and like Professor Patnaik said, from the Dalit Bahujan perspective. In fact, I was told that the three presenters would present from different perspectives. Asma from the Muslim women's perspective, Mr. Mahapatra, I was not very sure which perspective, and I from Dalit Bahujan perspective. And it was a pleasant surprise to see that Mr. Mahapatra almost spoke from the Muslim women's perspective. I'm sure we'll have many interesting things to debate there. In fact, I also have another question which many of my friends raised. Why a debate on UCC right now? Right? I mean, have not seen anything, at least openly, on UCC, a debate on UCC or news reports on UCC. I might have missed it, but when many friends asked me, I was not sure. I'm hoping there will be some discussion on why a debate on UCC right now as well. I like to start from the basics. Although I'm the last speaker, I just want to talk about what exactly a uniform civil code is. So, and I largely read from what I have written down. You'll have to excuse me for that. A uniform civil code in India is the proposal to replace the personal laws based on scriptures, customs of each major religion with a common set of laws governing every citizen. And UCC, as it's obvious, is a set of laws that covers the personal realm, which covers marriage, divorce, inheritance, custody, adoption, and maintenance. What I won't touch upon is that UCC assumes that this relationship between people is necessarily heterosexual. That's an aspect that I'll not touch upon, but perhaps we can discuss. And as Mahapatra and Asma pointed out, this idea of a uniform civil code has a long history and also is enshrined in the Article 44 of our Constitution, which says the state shall endeavor to secure for all citizens a uniform civil code throughout the territory of India. So from there, what exactly exists now in the realm of codified laws? In fact, as I said, India operates on various personal laws. This is not true just for India, but a whole lot of countries. Almost all our neighbors operate on personal laws, be it Muslim, be it Buddhist, or any other religion. Most of them operate on personal laws. In India, there is, of course, the Hindu personal law, which is codified at various points in history and codified in various bills. There is also the Muslim personal law. There is the Indian Christian Marriage Act. There is also a special marriage act that facilitates interreligious marriages and intercaste marriages and so on. There's also a Parsi Marriage and Divorce Act. In fact, the Hindu personal law collapses Sikh, Buddhist, and the Jains into Hindu personal law. So it doesn't differentiate the Jain personal law or the Buddhist personal law. The only state which kind of operates on uniform civil code in India is Goa, which has continued its Portuguese legacy and continued the uniform civil code that the Portuguese had enacted. Very interestingly, this Portuguese uniform civil code, which even continues to be in place today in Goa, allows a Hindu man to be bigamous, to marry twice, if the wife doesn't have a child by the age of 25, or if they doesn't give the man a male child by the age of 30. Right? And of course, there are exceptions for this kind of laws in states of Assam, Nagaland, Meghalaya, Mizoram, and also some communities in other states. From this kind of a basic introduction to Uniform Civil Code, I'll go to this current urgency to have to pass the bill on UCC. So in the campaign prior to the 2019 Lok Sabha elections, BJP's manifesto had it very clear, a move towards UCC. It said, it also cited Article 44 of the Constitution and gender equality. And the manifesto claimed that an UCC will protect the rights of all women, I quote, drawing upon the best traditions and harmonizing them with the modern times. So there are three things from this manifesto I'll focus on. One, best traditions. Two, rights of all women. And of course, modern times and harmony. Let me start with rights of all women. So throughout the time I shall, as I said, touch upon these things. And throughout the history of last 500 years or so, through the projects of Western European modernity, through colonialism, through nationalist struggles, to the current nation states, it is very, very surprising that women are always at the center of reformist tendencies. This has not changed in the last 500 years. And I often wonder why women are so, whether actually women are willingly sacrificing and they're unwilling to change, or it is the men who require change, but of course that never happens, right? It also brings to mind this incident from BHU, Banaras Hindu University, last maybe 2 years ago, when there were rules of hostels that did not allow women to go out, that said that do not go out, it is for your safety, do not use mobile phones, it is for your safety, and so on. So the girls said, if there is a thief, would you put the thief in the lockdown, or would you put the commoner, the citizen, under arrest? So it's like that. Although it is men who require reform, women becomes the center of reform question almost all the time throughout recorded history. So Mr. Mahapatra has actually pointed out how this has a history of colonial state. UCC has a history of colonial state, but I'm not sure how valid it is to justify UCC on the basis of colonial ideas and thought, right? So let's come to independence India and the earliest efforts, as we know, towards legalizing and codifying law was made by Dr. B.R. Ambedkar. And as part of the Hindu Law Committee, and also he was the law minister, Ambedkar presented the first Hindu Code Bill. And by now, one of the most famous oppositions. Of course, all of the people who opposed UCC then, the Hindu Code Bill then, were mostly men, and largely coming from what Ambedkar called regenerated caste, right? So most men, upper caste men, oppose the Hindu Code Bill. Now you see that this position has definitely changed. Like many things that change, the opposition for UCC has also changed. You don't have a similar set of men who are opposing UCC, but you'll find them supporting UCC. So one of the very famous oppositions came from M.A. Iyengar in the debates. So he said, "May God save us from having an army of unmarried women." So what is more important for me is the question of which women's rights need to be protected, because the BJP's manifesto says rights of all women. So as I was just pointing out, this obviously falls into this save the women syndrome, and to extend it a little further, save the Muslim women syndrome. The question which many Muslim women have asked: do Muslim women need saving? Right? What exactly? Who exactly needs to be saved? But I will not go into the Muslim women's question, but I'll stick to what Ambedkar said. And who are these women, all women who need to be protected? I'll quote from Ambedkar during his presentation of the bill. Quote, "Nobody has ever probably made any calculation as to the total number of Shudras who compose the Hindu society." Can if our audio is on, can we just turn it off? Sir. So I quote from Ambedkar. "So nobody has ever probably made any calculation as to the total number of Shudras who compose the Hindu society. But I do not have the slightest doubt in my mind that the Shudras form practically 90% of the total population of the Hindus, what are called the regenerated class." So I was quoting Ambedkar, and he is asking the constituent members whether we are going to have the law of 90% of the people, 90% of Shudras as a general law of this country, or are you going to have the law of 10% of the people being imposed upon the 90%? That is a simple question which every member must answer and can answer. So there's a whole lot of issues that Ambedkar raises in 1951 that are relevant to the debate today. Who exactly is a majority, right? And second, can we understand majority only in terms of numbers? Third, who gets represented in a democracy? Whose law, whose culture, whose customs get represented in the democracy? And how exactly do we understand a majoritarian democracy? So the parliament in which Ambedkar presented the Hindu Code Bill and the opposition he met varied from Sardar Patel, Pattabi Sitaramaiah, Iyengar, Madan Mohan Malviya, and Kailash Nath Kadzu. Right? Needless to say, all are twice born men, and now who would support the UCC. So Ambedkar was pretty clear that the reforms Hindus had to go through was largely at the level of the upper caste. It was their culture that needed the reform and not that of the Shudras. It was their women who were bound by the scriptural law. Largely he took from Mitaksha and Dayabaga, who suffered as widows, who hardly had any inheritance rights, and it was the upper caste women who could not divorce, or once divorced or widowed had no custody over their children and were bound by customs that made their lives pretty much unlivable. The widows in Brindavan even today are a case point. In contrast, the thousands of castes that are loosely categorized as Shudras and as scheduled castes and their customary practices varied largely or were largely non-existent, non-visible, or were not so rigid. To me, this is largely an issue with property as well, because most Shudras and other oppressed castes, household property or landed property is negligible. They hardly hold any property. There is hardly any property to inherit either for the men or the women, and therefore family ties, gender roles, gender rights, and kinship relations revolve around other customs, rightly seen as more just than that of the oppressive caste. So then Ambedkar is basically asking for a reform of upper caste men and women based on the better practices of Dalit Bahujan customs. How has this changed from 1951 to 2020, right? There's a whole lot of change from opposition to the support to the issues that are at hand. I think what has changed is this. The status of upper caste women definitely has changed. They are better educated, they are better literate, they participate in organized economy, they participate in jobs sectors, they're able to accumulate property, accumulate assets, and are able to be mobile and articulate in public and assert their rights at various levels. Now, this cannot be said of Dalit Bahujan women at all. But as Asma pointed out, there is a new level of visibility in the last 10 years or so, which we can discuss again. So from a perspective of 1951 to that of now, in 1951, which saw little requirement of change for the Dalit Bahujan, to 2020, we see that the women's question and the woman who is at the center of UCC's reform is actually the Dalit Bahujan woman and the woman from the minority. And this is a huge shift, which women have to change. So you have a huge shift there. And to add to this, that the government has not released the caste census data, which was conducted in 2011, the socio-economic and caste census, all the more proof to see how the connections between socio-economic status in independent India and other factors of inequality that are obviously caste bound. I want to make my argument clear when I'm talking about this, which are the women that UCC seeks to reform, right? So we kind of have this picture that upper caste women, despite being born into rigid customary laws, have largely been able to assert their rights precisely because of their caste capital and socio-economic capital. They are almost reformed. They do not read reform now. Whereas the Dalit Bahujan women and the minority women are perceived as struggling despite better customary practices. And of course, this is also because of some level of normalization or various levels of normalization of upper caste values itself. To give you one quick example of Radhika Vemula, I mean, Radhika Vemula, mother of Rohit Vemula, who was a Dalit woman who married a BC man, but to date, she has been struggling to prove that the kids she raised belong to her caste and not to her husband caste, who deserted the kids and the wife long ago, right? How does UCC address such kind of a question? Will the children of a woman belong to her caste or belong to somebody else's caste. Even if it's the same caste, will the children ever belong to the women? Will there be a gender just law, such a gender just law? So that also brings me to the second point, best tradition. So UCC points out that we'll take the best tradition in order to protect the women's rights, right? So what are these best traditions that are so good for women? Let us admit that tradition is a very tricky concept, and I have no clue how BJP's think tank has used this word in its manifesto. I'm willing to take the risk and assume that they mean the tradition, by tradition, they mean that they're customary or cultural practices, right? Also note that these customary practices have changed over time, be it whichever caste Hindu, or be it whichever denomination of Islam or Christianity. Customs have changed over time, like the laws that have changed and like the opposition to UCC that has changed. Nothing has been constant. So customs have also been changing from within the community and outside as well. I mean, I would, on a lighter side, you see that there are 5 people in this panel, including the dean and the chair. Dean who is organizing. All of us are short haired, right? Which is a custom, I'm sure, which was not allowed even for men some time ago. And men and women sitting together, I mean, whether it's virtual or physical, and discussing such a thing was also not really customary. So there are a lot of customary things that keep changing. And I would like to quote from Yuval Harari's Sapiens, A Brief History of Humankind, which I've been reading and kind of publicizing. I quote, "The heated debates about Homo sapiens' natural way of life, best way of life, miss the main point. Ever since the cognitive revolution of 70,000 years ago, there has not been a single natural way of life for the Homo sapiens. There are only cultural choices from among a bewildering palette of possibilities," right? So basically, Harari argues that human culture and human history is based on several myths that are propagated over millions of years ago, and there is no single myth that can bend us into behaving in a linear kind of a manner. And law, needless to say, the idea of nation and the idea of a uniform law definitely is a myth that is added to this history of myths. So
Sorry to interrupt, Soumya, half a second.
Oh my. Okay.
Actually, no, sorry, 6 seconds to be precise.
Maybe I'll just stop here and I'll talk about the other 2 pages I have during discussion. Yeah.
Do conclude, Soumya, if you wish to. Another.
No, my conclusion was like, I think what I want to say is there are a whole lot of best traditions available within India, whether be it matrilineal practices, be it community holding of property among various Adivasis, various tribes. But the major point I wanted to make is this, how it is the lack of universal public education, the language of rights that is inherent in this formal schooling, which alienates a whole lot of Dalit, Bahujan and minorities, right? Which disconnects them to this majoritarian kind of law, majoritarian kind of a culture. The language, it's not just the language that is different from, different, which is spoken from at home or in the school, but a whole lot of language of rights and the language of culture that separates our large citizenship from that of what is understood as language of rights. So I think it is what we need to do is the universal public education that kind of makes you proud, right? The times when we are able to work with the language and cultural politics that relates to the majority of the population, the times when we are able to provide such an education in languages accessible to all, and universal public education in letter and spirit, where all children have the opportunity to take pride in who they are, what they know, and what they do, And that time will be the time when communities will assert their rights and women will lead them. To me, neither UCC nor any other law from above is a match for such a vision of education which began from Savitribai Phule's efforts. And I am not at all sad to say that the European idea, a very colonial idea of one language, one nation, one religion, one law, is a thing of 19th and 20th century. It's not a thing of 21st century. Thank you.
Thank you, Dr. Samya, for again a provocative presentation. And we have had three thought-provoking presentations. I'm sure a lot of students have questions. So let's go to the students and other participants from the university and outside who are listening in. So I'll unmute myself. I'll mute myself, and those of you who have questions, please one at a time. Do you want to go ahead? Okay, why don't I start by reading some of the questions in the chat box, which I think the speakers can also take a look at. And we'll begin by responding to those, and maybe by then others will join. So one of the questions here by Ms. Shraddha: how do we think about the process of UCC centered on gender equality in light of the Islamophobic outlook of the ruling regime? So maybe that, and then a related question: can we go beyond the community-state boundary from the legal and academic perspective, since state is also constituted of the cultural and traditional aspirations as that of the community? So there are two questions, and if participants want to just pick, speakers want to pick up on those questions, Mr. Mahapatra, do you want to begin with the first one?
Yeah, sure. So the question that is being asked is, collating or relating UCC with CAA. And the presumption has been made that the ruling dispensation is Islamophobic. I would request Ms. Shraddha to go into the plans and programs that has been launched by the ruling dispensation since it came to power. And therefore to say that, draw a general conclusion that it is Islamophobic, according to me, is wrong. And please do remember that during those protests against the CAA, it was the preamble of the constitution that was being used as a tool or a mark of protest. And if you read the preamble of the constitution, it talks about secular, it proclaims India to be a secular country. It talks about equality and fraternity. And UCC, as one of the speakers has rightly pointed out, it could be seen in the equality terms also. And therefore, my answer would be that these are two different aspects, and this cannot be correlated. And since you have raised the issue of CAA, please do remember that CAA has been in public domain since 2004 or 2005. The opponents from the left who are talking about the CAA now as discriminatory are the ones, and there are like speeches made by Mr. Prakash Karath and host of left leaders who have spoken about the plights of Hindus in the neighboring countries of Pakistan and Bangladesh. And therefore to say that CAA has been brought about or pushed about by this dispensation is totally wrong. Post 2004-2005, a committee was constituted in 2012. That committee took submissions from various people, thousands of people, and nobody raised this issue of this is being Islamophobic and so on and so forth. This is an argument that has been built up so as, I'll say that, so as to propagate a view that the government of the day is Islamophobic, quote unquote, without going into the question that in the past, if you go into the past, the riots that have taken place in the past, which was the regime in which those riots have taken place. And therefore, I'll request you not to correlate or conjoined CAA and UCC. These are two different things. The point remains that when it comes to UCC, there has been an effort and concerted effort by talking about various other things rather than UCC. And therefore, we need to, according to me, separate these two things, and UCC and CAA. And it is to say that the government of the day is Islamophobic, according to me, is totally wrong.
Thank you, Mr. Mahapatra. I think there's also another question about going beyond a community state boundary.
Yes, yes.
Yeah, I'm thinking of the state as. I mean, this is a converse of the earlier question. So, would you like to respond to that too?
Correct. Yeah. So basically, when you are talking about any legal framework, you need to take into consideration what the community is, what the state is constituted of. If it is community, and if it is a country that is governed by a constitution, yes, we'll have to talk about those communities also. The betterment of those communities, and those provisions have been enshrined in the constitution, and the constitution has to be followed to the T to provide the betterment of the community in whatsoever manner is possible. One of the earlier speakers spoke about the plight of upper caste women when India got independence. In the last 70 years, according to her submission itself, things have changed, and things are changing insofar as those whom we classified as deprived in the last many years, because of the positive actions that has been emanated from the government or from the various states, things have changed, and therefore the perspective that we need to look about is from this perspective, that yes, changes are happening, rather than seeing it from a perspective that everything is wrong in this country and things are not going in the right direction. Unless we have that kind of an outlook, our debate or our views, according to me, would be centered around this, and therefore those aspects also have to be looked into as to the community, whether or not a community which has got some benefit from some scheme of the government or some scheme of the society itself, that also needs to be taken into consideration while we are talking about these issues.
There's yet another question. There's another question for you also, Mr. Mahapatra. I think the questions keep coming. So
yes, I read that question. It talks about if UCC comes into existence in India, will it actually? Okay, just a second.
Reduce the community participation.
Sorry, actually reduce the community issues, particularly in Muslim communities. It is a valid question, Mr. Malik. Thanks for asking this. See, the point is, unless we discuss about these issues, these are issues which needs to be discussed. And as I said, there have been voices which are coming from the Muslim community, and one of the panelists, Asma, has also pointed about this, that yes, there are voices coming from the Muslim community talking about reforms that needs to be brought about. And if the voices are coming from the community about whom we are talking today, that is a positive sign. And I would say that yes, in some manner, it would have some positive impact. But the fact remains, and the bottom line remains, as I already said, and I've already submitted in my discussion, is that we need to discuss all these issues with an open mind, rather than talking about, at least the BJP is talking about the UCC. Please talk about the other political parties. What happened to the left political parties in 1985 were gongo about UCC? What has happened in 2020? We are talking about progressive society, progressive country, and whatnot. So what has changed between 1985 and 2020, or rather in all these years? What has prevented them from talking about UCC? You may criticize by talking about the manifesto that has been given by the the BJP. It has been there not only in 2019; it has been there since long. Is there any other political party which has even bothered to talk about UCC? And if not, why they have not bothered? Is it vote bank politics, or is it appeasement politics? These are issues which needs to be discussed if we want to find a solution about UCC.
I don't see any more questions, but why don't we see if nomadic tribal women?
Yeah, there is a question regarding the rights of nomadic tribe, and I thank Mr. Dr. Ramesh Babu to raise this issue. This issue came up before the Supreme Court in the 1990s in one of the cases that was filed by Madhu Purnima Kistwar, if I remember correctly. And this was regarding the Nagpur Tenancy Act, and the issue was regarding the tribal women's right of inheritance of such land. The Supreme Court did not specifically go into this issue. The plea that was made was that the custom has to be declared as null and void insofar as the constitutional aspect is concerned. The Supreme Court did not venture into that aspect, but the Supreme Court provided some measure of help or succor, so to say, to such human, saying that yes, even a tribal woman would have some right even within the contours of the customary law. And therefore, we have various tribes which are matrilineal tribes. If we go to the northeast, those are matrilineal tribes, and those have different, customary this thing system, and they have better rights in terms of, if you analyze in terms of the property right and inheritance right. There are various other tribes also where the patrilineal or patriarchal system, as we know, is being followed. But the point remains that these are issues, because see, one of the argument that is being made about UCC is, what about the tribal rights? What about the rights that have been protected by the various provisions of the Constitution? The fact remains that these are issues which are being discussed, going to the extent of the Supreme Court analyzing these issues. So the right to, according to me, would be to discuss and analyze what are the impediments, if at all, when we are talking about UCC, whether or not the best practices which is being there can be, grouped and discussed and spoken about, rather than stonewalling the discussion itself. Thank you. Is there any other question, ma'am?
I am looking at the chat box. So yes, go ahead. Madhuri, Miss Madhuri wants to ask a question. Please go ahead.
Yeah, am I audible?
Yes, you are.
Yeah, good afternoon and sorry, good evening. Thank you for a brilliant session. My question, I think, would be specifically for Asma ma'am, if I know her name correctly. I think the buzzword today would be reform within communities and reform between communities. I think that has caught my imagination quite a bit. Two things I'd like to refer to here. In Nagaland, we have about 200 tribal communities, and they have each has their own customary law. How are we to look at it vis-a-vis UCC? And secondly, there was a time when the Sikhs were very, very retaliative of, they being considered under the Hindu law, so much so that they burnt the copies of the constitution also. Now, how would you look at it within this UCC debate? Because, when we vouch for UCC, I think it looks, at least as a political scientist, I think it looks a little too far-fetched. My apologies to Mahapatra sir at the moment, yes.
Your question, Madhuri, is about how there are different customary practices in Nagaland, etc., right? And how will that sort of have its impact or not on the whole question of a uniform civil code? Yes, I think as one of our panelists already has pointed out that 371A and 371G in terms of Nagaland and Mizoram, they exclude the applicability of this uniform civil code, and so the lawmaking power about in terms of family law, etc., is delegated to the district or regional councils in these tribal areas. Also, for example, in terms of scheduled tribes, the whole Guardianship Act, the Hindu Minority and Guardianship Act of 1956 doesn't apply. So yes, these are all issues which sort of fracture this idea of a uniform civil code. Where is this uniformity going to come from? What is it about? And that is one of the key issues, that we really don't know what this uniformity is about, because how tribal women rights, or this is another question from someone. But let me just go back a little to somebody who said, I think it was Anjali who asked whether we can go beyond community and state boundaries, etc. I have lost the question in the chat box. Yeah, can we go beyond the community state boundary from the legal and academic perspective? And I thought that's an interesting question if you think about it, because since the state is also constituted of the same cultural traditional aspirations, you just answered the question yourself. As the last panel said, that there is a way in which the people who made the laws, the interests which were represented when these laws were made, the point of view or perspective which was put into place, very much comes from access to resources. So the language of equality, the language of access to resources, none of this is operational at the moment. So how do we go beyond any kind of boundary? There is no way we go beyond boundaries, because for me, we are operating with all of these, within all of these paradigms, rather than boundaries, I would say, within all these paradigms. So I'm not, for me, the question of going beyond anything doesn't seem to be a very productive way of looking at it. I would rather look at it in terms of whether all of this is possible. And this is where I would tie it to Madhuri's question about what happens to the rights of tribal women. And clearly, yes, there is no view here, there is no vision here. We seem to have a blanket thing about uniformity that we are not thought through. And as somebody else, I forget who, tried to connect the UCC to the CAA, my thing is that these are different domains. The discussion about UCC has been happening for a long time. CAA, of course, also has been happening for a long time. That's a different trajectory of thought, and I would pick it up very differently. But I'm not going to go there now. But Uniform Civil Code has had a history, and it has had a whole lot of discussion which has come from the women's movement, from feminist thought, from critical legal perspectives. And all of this is erased or effaced or lost when we sort of map UCC only onto a particular community. It doesn't work like that. On the ground, it's not going to work like that. For example, as the Portuguese Civil Procedure Code, which Soumya spoke about, there is a limited form of bigamy that is actually allowed, permitted by law. So what kind of uniform law is working in that context? So there are all these kinds of caveats, if you like. And I do not think that any kind of uniform civil code is going to be a panacea. It is not. The way we hear about it, it seems to be some kind of panacea, which, as Mr. Malik said, is going to reduce the community issues. I would rather that instead of focusing on community issues, I would focus on the rights of citizens. The rights of citizens to have access to education, to have access to healthcare, to have access, given the current situation around us, to livelihood. All of these things, I think, are much more important in the current context where we are, especially in the 21st century, as Soumya rightly located us, brought our attention back. So for me, this whole idea of uniform smacks of a panacea, which really doesn't work on the ground.
I think Soumya wants to add to this discussion. So go ahead, Soumya.
Thank you, Vasanthi, and also thanks to Asma for making this easier for me. Mr. Mahapatra quoted me and said, yeah, the status of upper caste women has changed from 1951 to today. But let me remind all of us, including myself, that this is not because of the Uniform Civil Code, right? This is because of various other factors. And what are these various other factors? Like Asma pointed out, from livelihood to education to health, access to a whole lot of things that can make our assertion of rights much more easier. I mean, that is one. If law was a universal kind of a equality bringer of equality, I mean, I would like to ask if the Dowry Act, if the Prenatal Sex Selection Act, or if the Equal Inheritance Act, that is in the Hindu Inheritance Act, if these have actually changed the things on the ground. How many women, I mean, you can count here in this webinar, there are around 100 people, assuming that there are 50 women. If these 50 women, highly educated, very articulate, whether they have equal inheritance right, equal property rights within their own families, despite the Hindu Inheritance Act, which has been amended at various stages, right? Whether Dowry Act has stopped dowry, whether Sex Selection Act has stopped killing of various Hindu girls in the womb, right? So it's the culture, and it is the patriarchal culture among various castes that need to change, and not a law can bring about a uniform kind of a reform. I mean, a whole lot of laws we can keep on quoting, not to mention, as I said, I gave the example of Radhika Vemula. Can children actually take the name of the mother? Should they take the name of the mother, right? Or whether the groom will reside with the bride's family, will the groom or the husband take care of the wife's parents? So are these gender just? Will UCC kind of create such a gender just kind of a society? I'm not at all sure, and I don't think so. So, access to a whole lot of things which will make women more assertive is the need of the hour than think about one law which is coming from above, which, as I said, whole lot of examples for us to disprove that kind of a argument.
You, thank you, Soumya. Sneha wants to ask something. I think she has a long comment. Do you want to come in, Sneha? Sneha, can you hear us? No, I think there's something. You can all see her comment on the in the chat box, so I don't have to read it out. I think Rizwan Rashid, do you want to ask your question, Rizwan?
Hello.
Yeah.
Hello. May I ask a question?
Yes, please.
Yeah. The question is to Mahapatra sir. Sir, the Law Commission of India stated on August 31st, 2018, that a universal civil code is neither necessary nor desirable at this stage. And what is your take on it? You said that it is necessary, but the Law Commission has declined. So what is your take on it? Can you please elaborate?
Yes, thanks, Dr. Pramod, for asking this question. I was expecting this question to be asked. I was rather surprised as to why it has not been asked till now. As we know, the Law Commission is tasked from time to time by the government to talk about and deliberate on various issues that are being faced. Please also remember that the Law Commission in the past has passed various, has given various reports, many of which may not have been acted upon. I need not go into that issue. But the fact remains that the Law Commission is not about the Supreme Court. The Supreme Court, in various judgments, starting from the Savano judgment till Saira Bano, and in 2019 also, talking about the Goa Civil Code, it has emphasized on this issue that yes, Uniform Civil Code has to be spoken about at least. Talk about Uniform Civil Code. Don't let it be a dead letter of our Constitution. Maybe it is in the directive principle of state policy. And these are the words used by the Supreme Court. So when the Supreme Court is exhorting us time and again, the Law Commission may have a certain view, but the fact remains that there are sections in our society who are willing to talk about UCC, who think that UCC would be a good thing for our country. And therefore, even though the Law Commission has taken a view, the Law Commission can be tasked with another by the government, if they so want, to have a relook, if at all. And therefore, if the Law Commission had said something and that is the be all and end all, that is not the right thing. The fact remains that yes, there is a debate that is going on about UCC. As I may be repeating, the Supreme Court is, insofar as matters of law are concerned, is the supreme in our country, and the exhortation that has been given by the Supreme Court. Please do remember that after the Triple Talaq judgment, a legislation was passed by the government. Okay, the Supreme Court in some manner also said that this is for the legislature to look into, and the legislature took up that challenge, if I may use that word, and passed the legislation, and now it has been legislated. Likewise, so as to talk about UCC, there has to be an atmosphere where there is, you can talk. I was going through the comments that were made by the participant. One of the participants, I'm not taking his name, I know who he is. He says that why do you invite RSS sympathizers like Mrs. Mahapatra? If that be the view in an educated group, then I don't know what would happen to UCC and talk about UCC. So the bottom line is that if you need to discuss, come with an open mind. Just because, yes, I'm an RSS Swayamsevak and I'm proud of that, and I don't need any certificate from anybody as to whether I should be invited or not. But the fact remains that this mindset of our way or the highway has to change for bringing about a good discussion on UCC. Thank you.
I'm looking to see if the Dean wants to ask any questions, because Arun, Are you there? Arun, do you want?
No, Sneha asked a question. I would like to repeat.
Yeah.
One of you can answer. Sneha says, is there any instrumentalization of women's rights? I unmuted. Is there any instrumentalization of women's rights in UCC? Do you find this taking place? Do you think that UCC is using women's rights as instrument? Instrument for what? I am not very clear what she says. But do you think a hint that UCC is trying to instrumentalize women's rights? Probably Sandeep can tackle that question. Do you get a question, Sandeep? Sneha asked the question, do you find...
Yes, this is, I think this question is more addressed to Dr. Rasid and Soumya.
Yeah.
Pointing out that instrumentalization of women's right in the UCC debate, what can be some of the visions of solidarities within women's movement in India, especially when faced by jealous savior of stances, whereby the differences within are often pushed to the margin. So,
yeah.
I think these are questions that has been asked to them.
Thanks, Sneha, for picking that point up, that there has been a great deal of scope and there has been a lot of solidarity across women's groups. Yes, there has been, much has been written about, as I think Soumya also mentioned, we pointed out again and again, there are different ways in different kinds of communities are envisaged or looked at how women's rights go about, and women from different communities are speaking up. I am not talking about giving space to them. I'm saying that they have arrived on the stage where a new generation of people, whether it's women wearing hijab or whether it's women from Dalits and other marginalized communities, from Adivasi groups and so on, they have come and they are speaking, and we no longer need to speak for them. They are there. They have written about it. They are writing about it. They're speaking up. In fact, this brings us back, if you look at some of the discussions, issues, some of the protests and other things which happen in the public spaces during the anti-CAA period, when there were a lot of protests and so on from the last, before the pandemic kept.
You have got muted. Please unmute yourself.
Okay, I'm not sure at what point I was unmuted.
You're talking about the anti-CAA protest.
Yeah, I was saying that the great deal of solidarity was exhibited and did come to the fore during that period. And so, which is just a new or a fresh or the latest, if you like, instance of when we had different visions of solidarity actually coming out in the public space. So this has very much been there throughout the history. It depends on where we are coming from and how we are looking at it. And there has been a lot of, yes, a critique of these zealous savior stances, as you put it, where differences are effaced, pushed out, and this whole talk about uniformity seems to become a mantra. And actually, I would like to point out here that uniformity, the idea of a uniform civil code is being posited is very different from this whole notion of a common civil code which somebody else has mentioned. So I don't think that both of these are the same. And that certainly legal pluralism will operate if we allow all of these different perspectives and visions to flourish without reducing rights to this realm only. Yeah.
Maybe Soumya wants to add to that.
Yeah, just to add to a small thing that I think once you work with local communities around you, I mean, whether it may be the university where I live in, or it may be any other locality where we live in. And of course, social media makes it easy for us to connect across, right? As Asma pointed out, in last year, we have seen huge solidarities across. So I think working with the local and connecting with social media, and of course, despite being trolled by various kinds of people, whether mildly or even horribly, all these things work. Answering the next question, Anuja Jayashankar, who says just a statement and not a question. Just because laws are not implemented doesn't mean that laws should not be made. I totally agree. What I mean is that we'll have to take into consideration that it's not just law that changes a people, right? And that's the examples I was giving. There are a whole lot of other factors that can enable everyone's rights. And there are a whole lot of other practices that actually law misses, right? Whether law actually would take into consideration gender just practices that already exist within a community, right? So will a common civil code or a uniform civil code erase all such practices? So it's not that law should not be made, but law is not the answer, and definitely not a magic wand that will change things. There are a whole lot of other factors which we need to keep in mind that enable the rights of everybody around us.
I think if there are no more questions, then we can head to concluding this session. I don't see any in the chat box. So do I have the Dean's permission to close the session, or would the Dean like to? Hello? All right. As we have had about a couple of hours of useful discussion, and it appears that we will still be discussing inconclusively, as it should be, the necessity, the possibility, the desirability of a uniform or a common civil code, both given the historical dialectics between communities, given the colonial past, given the limits of uniformity in legal constitutional sense, and so on. I think we have begun somewhere, and we hope to continue this discussion forward. Thank you very much to all the speakers for engaging with the topic and engaging with one another. Hope to see you soon in another webinar. Bye for now.
Thank you. Bye.
Thank you all. Thanks a lot.
Thank you, Professor
Thank you for
Patnaik.
Thanks, Professor Patnaik. Thanks, Dr. Vasanti. Thanks, Soumya-ji. Thanks, Asma-ji.
Thank you.
Thank you to the chair, to the dean, and to my fellow panelists. Thank you. It was nice to be here.
Don't worry, Sandeep. I don't take that RSS question seriously.
No, I just pointed that out. So I also didn't take it seriously, but then I thought.
Only one person has the question, so don't worry.
No. I'm not.
500, one person has the question.
In places like JNU and other places, we are used to those questions, other hostile questions, so it doesn't matter.
Okay, bye.
Okay, bye. Thank you.
Thank you.
Thank you.
Thanks a lot.